Let me change topics, Ms. Kagan. And this gets back to questions we've heard about the Commerce Clause. And again, this is the sort of the jurisdictional hook that Congress finds in legislating in areas that that have provided, I think we would all agree, rather expansive federal jurisdiction over much of our lives. And you mentioned yesterday the Lopez and Morrison cases, and of course those are a couple of cases that were decided when Chief Justice Rehnquist was chief. By 5-4, the court said that government actions that were defended as legitimate regulations of commerce must deal with commerce as opposed to non-economic matters. I believe you said as much. Do you agree with the court's decisions in Lopez and Morrison?
Well, Senator Cornyn, I've refrained from agreeing or disagreeing, but I do believe that Lopez and Morrison are settled law and entitled to the precedential weight that one gives to any decision.
Do you know, or do you recall whether you've ever written or spoken and expressing previously and having expressed an opinion one way or another about Lopez or Morrison? You know,
Senator Kyle asked me that question. I don't think that I've done any academic work on the subject. I don't know whether I've, spoken about them in any of my many speeches or anything like that.
Okay. Well, one document that that was among the many documents we got from the Clinton archives that has been produced, there was a memo you sent to the Deputy Chief of Staff at the White House on March the 31st regarding the recently decided Supreme Court case of Seminole Tribe versus Florida, where you noted the, quote, broad significance, close quote, of the opinion. In that memo, you said, quote, the decision, especially when viewed together with the holding last year that Congress lacked authority to prohibit guns near schools, indicates a serious effort by a bare majority of the court to reorient the balance of power between the federal government and the states. It's highly unlikely that this case will be the last one to pursue that states' rights agenda, close quote. Now, this language in your memo is strikingly similar to the opening paragraph of a New York Times article entitled Lurching Toward States' Rights that you attached to the memo that I just referred to. The opening paragraph of the article reads, quote, a headstrong 5-justice majority is driving the Supreme Court toward a revolutionary, indeed reactionary, interpretation of federalism, tilting the balance dangerously toward states' rights at the expense of federal power, close quote. Did you agree then that the article with that article that the Supreme Court's federalism jurisprudence was reactionary and dangerous?
You know, Senator Cornyn, I don't at all remember the article, and I've not seen it. I have seen more recently that memo, which I just sort of think of as the Seminole Tribe memo. It's a memo about the Seminole Tribe case. And I think that I was, what I did was I described that case. I guess I said, in light of Lopez, it does suggest that the court is reorienting the federal-state balance in this area, which I think indeed happened in those years. I think that was probably, if I caught that sentence that you wrote, I had referred to Lopez, but this was probably before Morrison. So I think that there were this set of changes that occurred in those years, and that memo was about neither of those, was about Seminole Tribe, which dealt with Congress's ability to abrogate state sovereign immunity under the Commerce Clause. So that was a few years of important developments in the law relating to the federal-state balance.
In fairness to you, what my question is about the article, not what you wrote.
And I've not seen that.
And the article refers to the Supreme Court's federalism jurisprudence as reactionary and dangerous. Do you agree with that characterization, or do you disagree?
Well, Senator Cornyn, I have refrained from saying thumbs up, thumbs down on any cases. I think
I'm not asking you that. I'm asking you, do you agree with the characterization that the Supreme Court's federalism jurisprudence was reactionary and dangerous.
It actually sounds, I don't even know what it means to be reactionary and dangerous, but the Morrison case, the Lopez case, the Seminole Tribe case are settled law. And I have, I'll say this, no plan, no purpose, no agenda, no anything to mess with them.
That's a legal term, I think, right?
Mess with them.
I have one last question. I'm sure that's welcome news. Can you name for me any economic activity that the federal government cannot regulate under the Commerce Clause?
I wouldn't try to, Senator Cornyn. The test that the current court is using is this test of economic versus non-economic, and that's the test that I would expect to use under settled precedent. And if there are cases in which, indeed, the claim is presented that economic activity should not fall within Congress's commerce power, those will be cases that I'll decide in the appropriate way by reading the briefs and listening to the arguments and talking to my colleagues.